All right, so first, let's talk generally on why it's important to work with an experienced EB-5 immigration attorney. And so there's kind of three major buckets here that we've broken down. First is by hiring somebody who knows what they're doing, you're likely going to be able to prevent errors, right? So just errors that can be caused by documents and explanations and things in the package that you're going to submit to the government. So just submitting a better package with less mistakes. Number two, you're going to be able to identify mistakes caused by USCIS quickly. So even if you submit a perfect package of documents and everything is written correctly, there's still, unfortunately, a decent chance that USCIS is still going to make a mistake. And it's not going to be your fault or your attorney's fault, but it's just going to be USCIS making a mistake. And so when that happens, you need to quickly address that mistake before it can fester and turn into something that could be, potentially lethal to your application. And then third, fix mistakes quickly. So once you do find a mistake, how do you correct it? And oftentimes, there's not a clear, obvious way to do it for someone who hasn't seen a similar mistake. And so that's why it's, again, critical to work with someone with experience. But I'll let Anaida kind of walk us through these three items and kind of give you some real life examples on how this plays out with real investors.
I think, Sam, this is a great slide. I think three is not talked about very often, but yeah, let's go through all of them. The first step is definitely preventing errors. EB-5 is a very niche space, and so it's constantly evolving. The interpretations that the agency used under President Obama are different than the interpretations used under President Trump, which is a lot different under President Biden and now again with Trump, right? So if someone's been in the industry long enough, we are able to track all the interpretations, look at all the RFEs, and then our combined knowledge, we're then able to apply that. So at least as of today, our firm has gone back to the standard we were using under Trump, right? We're very careful. We make sure that we cite everything that we're writing. We make sure every statement has a corresponding exhibit. The standard has changed significantly. Under Biden, they were approving anything and everything. Under Trump, they were applying policy. They were asking questions, and we expect that to return. So it's very important that the application is crafted properly and you don't have any lethal errors. There's the concept, there's case law that says that your petition needs to be approvable when filed. So if you're missing a significant chunk of your petition early on, that might not be something you can remedy later. I want to point out for point one is that there are two classes of attorneys in the EB-5 industry. One class, which is where my firm stands, is that we bill upfront and we do not charge for corresponding RFEs. We believe that we shouldn't have to be paid twice to do the same work, and our experience should be enough to prevent these errors or cause USCIS from coming back to us with questions. There's another model where a base, very preliminary petition is filed, and then attorneys charge for RFE by the hour. At that point, if you're from a country like India or China and your country is in the process of backlogging, you will waste 6 to 9 months in responding to the RFE and getting a response from USCIS on the RFE. There have been cases where it's taken years before the government gets back to us. So we definitely lay a heavy emphasis on filing the correct and error-free application, step one. We make sure that the client has the full packet to review so they can point out any errors that we've made, any typos, any edits. We try and incorporate all of that. So and definitely step number one.
And on that point, let's dig a little bit deeper. Why is that timing kind of delay aspect so critical for an investor, let's say from India, who's filed, who has a priority date, but hasn't yet been approved? Why is that, so critical to avoid an additional, 3 to 6 to 9 month delay in getting approved?
Yeah, so that's a great question, Sam. There's nothing in the law that mandates USCIS to respond to an RFE with the next number of days, right? So it's not that we submit an RFE and then USCIS has 60 days to respond. What happens is once you respond, they have unlimited time to look at it. They may forget about it, they may push it at a desk, And why is that important for Indian nationals? We saw in December that there was a warning shot fired by the Department of State stating that India might retrogress. In these cases, if we have clients that are outright approved, the government can move on and work on the 485 application, which is the application for conditional green card. However, if the petition wasn't filed properly and you've now ended up with a request for evidence, you are not getting a green card anytime soon. You're going to submit a response, you're going to wait 6 to 8 months. By that time, India will have retrogressed. And if your date is not current at the time of approval, there's no chance that the government's going to issue you a conditional green card. It could result in years of you waiting for the date to then move forward again. So I believe in filing a perfect petition just on step 1.
Got it. All right, perfect. That makes sense. So let's talk about number 2. So even if you submit a perfect application, what can happen?
Great question. We just had an RFE. Hate saying it, but the RFE stated, thank you for submitting your documentation. However, it seems like Exhibit 22 to 44 was lost. That is a USCIS error. The way EB-5 works is we ship a petition to Texas. Texas is a contractor. Texas pulls apart files, ships the I-526E petition to DC, which is where the IPO is, the Immigrant Program Office, Investor Program Office. In that process of shipping, files get lost. Some documents get lost. That is a USCIS error. At least with our firm, we've seen a 2-step approach. We've seen an RFE, and because we're very diligent, we're very quick, we have electronic copies of the RFE, we're now able to extract those exhibits 22 to 44, upload it to the government's portal, which is your USCIS account, and get approvals within 24 to 48 hours. So it's not like we're waiting, printing the file, shipping it. No, we're using technology where the government provides it to us, and we have an electronic copy of the file available. So we're not going to reinvent the wheel. We know there are a bunch of firms that are doing paper filings. We do paper filings as well. However, we also have an electronic copy available, right? That is not an error on my part. That is not an error on the investor's part. That is just merely a shipping problem, a logistics issue, and that happens more than you'd like. The second approach we've seen with the USCIS is instead of issuing an RFE, I received RFCs from USCIS, which is requests for clarification, where they actually acknowledge that they've lost a bunch of files and they'll just ask me to email it to them. This is the kind of relationship I believe we have with IPO because of our track record. We've had 100% approval rating. The government knows we don't file applications that are incomplete. So there's a lot of respect between IPO as well as our firm where we get these RFCs instead of RFEs. So, and because we're doing close to 10 files a week, we know what errors USCIS is making on a regular basis. Just like I said, they could lose exhibits. They lose photographs. They RFE on photographs. Recently, because their systems weren't talking, they were asking to see 526E receipts when adjudicating 485. All of this, if you're on top of it, shouldn't take time to respond. Our response rate is 24 to 48 hours to an RFE or an RFC, or just a USCIS error.
Got it. Okay, so we talked a little bit about fixing mistakes quickly, but what else is there really to say about, why it's critical to address these mistakes fast, and what can happen if, they're not addressed timely?
Yeah, one of the things recently that we've seen, Sam, is that USCIS has incorrectly, the contractor in Texas has been incorrectly reading the visa bulletin. And so they process the 526E files, but they kick back the 485 files for Indian nationals, claiming that there's no visa available. So you cannot concurrently file. We saw 16 of these come back in November and 7 of them in December. At that point, we came together as a firm and started posting colored pages with big warning signs and a copy of the bulletin, basically stating that, hey, India is current, refer to the rural category, this is a rural filing. This happens with a ton of experience. Again, we could have just sat and kept emailing IPO. We knew what the next step was. We knew that we were supposed to email Lockbox. Once we email Lockbox, it takes Lockbox 3 weeks to get back to us and state, hey, yes, this is a USCIS error. Yes, we'll retain your priority date. If you're working with someone who does not do EB-5 on a day-to-day basis, their idea would be, let's just reship the file. And if you just reship without communicating with Lockbox, you'll get a new priority date. However, if you get Lockbox to acknowledge their error, you get to retain the old priority date. So for example, we shipped out a file on November 15th. The government kicked it back on December 7th saying, hey, dates are not current. We emailed Lockbox. Lockbox came back to us and said, 3 weeks later, yes, this was an error. Please resubmit and we will retain your old priority date. And they request a FedEx tracking number so they can track that application coming back. Again, all of this comes from experience. And just to improvise going forward, as Sam has provided that example, we attach this document. If it's a rural project filing, we'll say rural dates are current for India or China or Vietnam or whatever it is. We attach this, and since then, we haven't received any files back. So I do think it's improved our process, and I do think that USCIS now understands what to look at because we're giving them that warning. The second thing we've noticed is the 956F receipt. So if attorneys are filing in projects that don't have a 956F receipt yet, but pursuant to a settlement that the agency entered in, the settlement states that if a project has submitted the 956F, and even if they don't have the receipt, however, they have evidence of the check cashed, you're now able to submit 526E. We had cases where we've submitted these 526E forms and the government has kicked it back saying, you did not provide a 956F receipt number. There was another battle with Lockbox at that step where we had to send the stipulation to Lockbox in order to retain that priority date. Again, all of this comes from experience. If you've kept up with case law, if you've kept up with settlement, you know exactly what to say to Lockbox in order to retain your priority date. Also, it doesn't slow down your process. So if you were to refile this application with the 956F receipt and get a new receipt notice and a new priority date, you're just going back in line behind people that are filing on the same day. You're not retaining your old priority date. So again, it's very important to work with someone experienced who sees this day in and day out. I have clients who get panicked and anxious and reach out to me and say, hey, was there an error on our end? What happened? Is this common? And I can easily say, yeah, here are 30 of redacted emails that we've sent to USCIS and them acknowledging their errors on all 30 of them. Extremely important to work with someone experienced, especially when retrogression is close, because if come February, close to the end of the month, you're filing these petitions and they get kicked back, your attorney needs to know what to do in order to retain your February date so you can concurrently file.
And let's spend a minute and talk about that. Just priority date, you know, we know that there's been a warning in the visa bulletin. Why is the priority date just so critical now, you know, with that warning being out there?
The priority date. So for example, let's talk about India. Today, the tables for current and high unemployment say current, C, which means it allows a client to file concurrently, which means it allows the client to file their 526E petition along with their petition for green card, along with their application for work permit and travel permit. If the dates were to retrogress, if the table was to say April 1st, 2024, you can still file your 526E petition, but what you cannot file is your application for green card. And if you cannot file your application for green card, you then don't have the ability to file for a work permit and travel permit, which is the biggest draw for EB-5 today for H-1B, TN, F-1 visa holders residing in the United States. They want that work permit. They want that travel permit. So we encourage our clients to file in January or the first half of February and not wait until the end of February. What we've been seeing is due to the stock market correction, we've been seeing clients wanting to wait. Clients become complacent. Hey, February was current, so maybe there's chance that March will be current, right? We have no way of knowing that. And to just give yourself some room and your attorney some room for administrative errors, you want to file in the first half of February. If you were to file in the end of February and the file gets kicked back due to administrative error, and you're working with someone who, say, does 2 files a year, they're not going to know what to do in order to retain your priority date, which is going to cause a lot of anxiety for the client. And if you lose that priority date and you have to refile in March, you can only refile your 526E petition, not your 485, not your application for work permit and not your application for travel permit.
Perfect. All right. Thank you for going into that detail. All right. So now that we've kind of spent time going through some of these specific issues, let's just kind of go through these quickly again, just at a very high level, and summarize in your own words, just why is this so critical, and why, have you had many investors, initially select another attorney who dropped the ball, and then now, they end up hiring you to, pick it up and take the ball, the rest of the way down the field.
Yeah. I just starting with preventing errors. We start by looking at 7 years of financials for all our clients. We basically have the clients provide all their bank statements, brokerage account statements, tax returns, W-2s if they're in the US. We analyze all that data, and we basically map all the funds that are moving across their accounts. This just helps us tie the numbers. The government knows that if a client is making $1.8 million and say 1.2 of which is bounced across accounts, the likelihood that the person has the legal funds to make this investment increases significantly. What we've noticed is clients come to us, and when they come to us, either they don't have a copy of the initial filing, which makes our life harder because we do not know what was said at step 1, or they have a copy and it's just 25 pages, which then makes our life easier because now we have a blank slate. However, it takes time to put this application together. It could take anywhere from 4 to 8 weeks to put a response to the RFE together, and that eats up a lot of time, and it's more expensive. It's expensive to fix an error because you have to backtrack what was previously said, and you can't contradict that was previously said by the attorney. Because if you do contradict what was said, then there's a material change in the petition that can lead in denial. So it's very expensive. So we have had cases where clients have said, hey, you're expensive than market, so I'm going to go to someone cheaper. And then the same client comes back and says, guess what? I have a 20-page RFE, please help me fix it, which then makes it even more expensive to fix, right? So extremely important to prevent errors. Under President Trump previously, he gave the government the authority to go straight from your petition to notice of intent to deny. He took away the ability, he gave USCIS the flexibility to not go to an RFE and then a NOID and then a denial. In a way, I had to agree with that because you were supposed to do the job right the first time. And if you do then get annoyed, you only have 33 days to fix that problem, which isn't enough time to put together a comprehensive source of funds packet. So especially under this administration, starting today, I believe it's extremely important to prepare a thorough package. USCIS mistakes, this is going to happen a lot. There's going to be churn in the agency. People are going to quit. You're going to get RFEs that make no sense. You're going to get RFEs with errors. If your attorney is on top of the case law, understand what cases have been settled, right? What arguments to make, it'll make it a lot quicker to respond to USCIS. And again, fixing mistakes quickly is just for the client's benefit. The longer you take to respond to a USCIS mistake, the longer it takes to get an approval following the mistake because the officer forgets about the file. Like I said, they're only looking at a file for 6 hours, then they're putting it on the shelf. And if you have an RFE, you send it back, it might just sit on a shelf because now they have no timeline within which they need to adjudicate your petition.